At this point, I'm going to turn the program over to Professor Fiss. He will be our first speaker this morning. Thank you.
Thank you. September 11th, 2001 marked the beginning of a new era in American law. Combating terrorism became a matter of great public urgency, and as part of that endeavor, policies have been pursued that compromise one sacred principles of the Constitution. These policies were initiated by President Bush, but with some exceptions, other branches of government soon endorsed them, and remarkably, they are now being continued by President Obama. In his campaign, Obama denounced Bush's policies governing the treatment of suspected terrorists, and in his inaugural address, vowed to continue the fight against terrorism without compromising our ideals. Much in keeping with this promise, on his first day in office, President Obama issued an executive order banning torture. In so doing, Obama gave expression to the International Convention Against Torture, the federal criminal statute enacted to implement that treaty, a provision of the Detainee Treatment Act of 2005 that had been spearheaded by his competitor, John McCain, and most importantly, the constitutional ban on torture, rooted in the Fifth and Eighth Amendments. On its face, this executive order, which after all only restated the law, may not be seen as much of an accomplishment. In truth, however, it put to rest the doubts created by President Bush as to his fidelity to the basic laws of the nation. Obama did not confine himself to this exercise in nominalism. He also tried to minimize the risk of torture actually occurring. On the same day that he issued the order banning torture, Obama closed the secret prisons maintained abroad by the CIA, the so-called black sites, and required the CIA to follow the Army Field Manual when interrogating suspects. On the other hand, and this is the important point, on the other hand, Obama brushed aside calls for criminal prosecutions and truth commissions to investigate the abusive interrogation practices of the previous administration. He said that he was only interested in the future, not the past, without understanding that how he treated the past will partly determine what will happen in the future. Obama's willingness to hold the prior administration accountable for torture caused a public outcry. In response, his Attorney General opened an investigation on a CIA interrogator accused of going beyond agency guidelines. The alleged crime was not waterboarding, which almost universally was and still is considered to be torture, but which appears to have been authorized by higher officials, perhaps if his recent memoirs to be believed by President Bush himself. Rather, the agent was accused of threatening a hooded and shackled prisoner with imminent death, first by revving an electric drill near the prisoner's head, and then by cocking a semi-automatic handgun in the same position. The investigation of this rogue agent was opened in August 2009, but without much energy and direction, and we still do not know what might come of it. Obama can also be faulted for not disavowing with any clarity the practice of extraordinary rendition under which the Bush administration sent suspected terrorists to countries such as Syria or Egypt that had routinely engaged in torture to extract information of value to the United States. In fact, on two notable instances, one in the Ninth Circuit and the other in the Second Circuit, Obama sought to block judicial inquiries into extraordinary renditions conducted by the Bush administration. These proceedings were brought by victims of the renditions and were pending before appellate courts when Obama took office. In one, Obama's lawyers relied on the state secret doctrine, transforming what was originally an evidentiary privilege into a de facto grant of immunity to the CIA. In the other, his lawyers claimed that any judicial inquiry into the practice of extraordinary rendition would compromise the executive's and perhaps the legislature's authority over military and foreign affairs. In contrast to Bush, Obama has been reluctant to treat the United States as part of the battleground against al-Qaeda. Accordingly, he placed within the ambit of the criminal justice system two suspected terrorists who were seized in the United States on his watch. One was an American citizen attempting to detonate a bomb in Times Square, and the other was a citizen of Nigeria attempting to detonate a bomb on a Northwest Airlines flight as it was about to land in Detroit. Yet, in a speech at the National Archives in May 2009, President Obama declared that he would continue Bush's policy of incarcerating suspected terrorists, suspected agents of al-Qaeda and the Taliban, without ever affording them a trial. This policy violated a basic constitutional principle, what I've elsewhere called the principle of freedom, that requires any person imprisoned by the United States to be charged with a crime and swiftly brought to trial. Like Bush, Obama claimed that there was an exception to this principle of freedom that allowed the executive to imprison persons captured on the battlefield and to hold them for the duration of hostilities without ever affording them a trial. He did not acknowledge the very special nature of the war against terrorism, a war without end, and the threat that the imprisonment without trial posed to the principle of freedom when it was applied to such a war. Bush claimed that the power to imprison without trial belonged to him as commander-in-chief. President Obama, anxious to avoid such extravagant claims of executive power, justified the pursuit of the same policy by pointing to the statute Congress had passed immediately after 9/11. But this statute did no more than authorize the president to use force in responding to the terrorist threats on that day. Although on occasion Bush tried al-Qaeda suspects in civilian courts, he also claimed the authority to try some before military commissions. and he did so without ever announcing the criteria that was to govern the choice between tribunals. Obama has claimed the same authority. Obama made headlines when he announced that he would try the alleged mastermind of 9/11, Khalid Sheikh Mohammed, in the Southern District of New York. The controversy that erupted over this announcement should not, however, blind us to the fact that Obama is prepared to try some of the Guantanamo prisoners before military commissions and is now doing so. Like Bush, Obama has failed to announce any criteria governing the choice among tribunals. Military commissions have been used on the battlefield to try belligerents caught red-handed and accused of war crimes. They have been allowed in these circumstances as tribunals of necessity. Bush had transformed them, however, and made them into tribunals of convenience when he announced that he would use them to try prisoners held at Guantanamo, far from any battlefield, who had by the time in question already been imprisoned for 4 or 5 years. In June 2006, the Supreme Court invalidated Bush's plan as inconsistent with the provision of the Code of Military Justice without ever reaching the obvious offense to due process posed by such an arrangement. Only months later, Congress, as anyone could have predicted, passed a statute, the Military Commissions Act of 2006, which fully authorized the use of military commissions as Bush had originally planned, and thus overcame the objection to them that had been voiced by the Supreme Court. As a senator, Obama voted against the Military Commissions Act of 2006, as he indeed should have. However, as president, he sponsored the Military Commissions Act of 2009, which authorized the use of military commissions for the trial of unlawful or now unprivileged enemy combatants. Admittedly, the principal purpose of this legislation was to strengthen the evidentiary rules governing military commissions. Under the 2009 Act, all coerced testimony was barred, the accused was given a reasonable opportunity to obtain evidence, the government's obligation to disclose exculpatory evidence was expanded, and the accused was given the right to examine any evidence offered at trial. Moreover, the political officer convening a military commission was prohibited from punishing members of the commission for any of their rulings. Still, the basic shortcoming of military commissions, namely trial by military officers, persist. Indeed, the 2009 Act, building on Bush's initial executive order of November 2001 and the Military Commissions Act of 2006, represents a further institutionalization of military commissions as an irregular alternative the executive might choose on criteria we will never know for the prosecution of suspected terrorists. Much like the 2006 Act and Bush's November 2001 executive order, the 2009 Act defined the offenses that could be tried before a commission to include crimes such as giving material aid to a belligerent that could not possibly be considered crimes under the laws of war. The irregular nature of these military commissions was underscored by a provision of the 2009 Act, also present in the 2006 Act and the 2001 Executive Order, confining them to the trial of foreign nationals. The unmistakable implication of such a limitation is that these tribunals are not good enough for Americans. Obama has sought to follow through on the promise he made in the course of his campaign to close Guantanamo. On his first day in office, he signed an executive order purporting to close Guantanamo in 1 year's time. In December 2009, he announced a plan to transfer the prisoners still remaining in Guantanamo to a federal prison in Thompson, Illinois. This plan has encountered congressional resistance and has not yet been implemented. It should be emphasized, however, that once Obama decided, as he did in his May 2009 speech at the National Archives, to continue the practice of using military commissions for the trial of some of the Guantanamo prisoners, and to continue the policy of holding other Guantanamo prisoners for prolonged, indefinite periods of time without trial. The closure of Guantanamo has become a gesture of doubtful significance. Guantanamo became an object of public controversy and was denounced during the 2008 presidential campaign, not just because it was viewed as a site where prisoners were tortured, but also because Bush had planned to use military commissions to try some of the prisoners being held there and to continue the imprisonment of others being held there without ever affording them a trial of any type. The notoriety of Guantanamo had also arisen because President Bush insisted that the prison lay beyond the reach of habeas corpus. He had turned it into a legal black hole. The June 2008 Supreme Court decision in Boumediene versus Bush relieved Obama from taking any position on this issue. For in that case, the Supreme Court upheld the constitutional right of some Guantanamo prisoners to the writ of habeas corpus. Obama complied with the court's ruling in Boumediene, as I'm sure President Bush would have, but Obama has tried to limit the scope of that ruling, and in so doing, further denied the act of closing Guantanamo of much of its meaning. Obama's lawyers have argued in open court that the Boumediene decision should be confined to Guantanamo and only Guantanamo, and that the prison at Bagram Air Force Base in Afghanistan, a prison maintained by the United States and one to which terrorist suspects from the four corners of the earth had been brought, lay beyond the reach of the Constitution. At the time of the argument, Bagram held close to 600 prisoners. In the Bagram case, the district court applied the criteria Boumediene had announced and found that habeas was available to prisoners who were not Afghanistan citizens. But the Court of Appeals, also applying these same criteria, reversed the district court's decision and denied habeas to any prisoners at Bagram. Now the prisoners are, with the blessing of the Court of Appeals, back in the district court claiming that they have new evidence that is relevant to the application of the Bermuda-Dean criteria, and further suggesting that the executive had brought terrorist suspects to Bagram as a strategy for defeating any claim of habeas corpus, or arguably, as the Court of Appeals put it, for turning off the Constitution. Such protracted litigation is not at all surprising to me, given the multivariate test Justice Kennedy had laid down in his opinion for the court in Bermuda-Dean. In truth, there was nothing more than a laundry list. But what is remarkable and disturbing is that today President Obama denies that habeas corpus is available to the prisoners at Bagram, just as Bush had denied it was available for the Guantanamo prisoners. In assessing the record, we must, of course, be careful to note the differences between Bush and Obama. Yet the essential truth is one, I'm sad to say, of continuity. Obama has not disavowed extraordinary rendition, as in fact sought to block judicial inquiries into that practice. Obama has continued the policy of imprisonment without trial. Obama has continued to use military commissions to try terrorists. And Obama has sought to deny the writ of habeas corpus to the prisoners now being held in Bagram. Obama sometimes announced these policies with great reluctance, never Bush's style. Indeed, Obama is a thoughtful and reflective man. But in the end, Obama overcame this reluctance and chose to sacrifice principle. The reason for Obama's perpetuation of Bush's policies are hard for me to understand. Perhaps he learned things about the nature of the terrorist threat that he did not know as senator. Maybe Obama compromised on these issues of principle in order to gain the support for a number of his other policies, health care, or economic recovery, all truly worthy. Or maybe Obama has been unable to resist the momentum achieved by the Bush policies now that they have been endorsed by Congress and tolerated by the Supreme Court. I just don't know, and we will probably never know. Our concern should be, however, not with the reasons, but rather with the consequences of Obama's actions, which are unmistakable and troubling. At the beginning of the decade, and reflect back, it has been a decade. At the beginning of the decade, and in the immediate wake of 9/11, the abuses of the Constitution governing the treatment of prisoners in this war against terrorism, torture, extraordinary rendition, imprisonment without trial, the use of military commissions, and the denial of habeas corpus were seen as aberrations, perhaps unilateral excesses of Bush and his close circle of advisors. After the disclosures of the scandal Abu Ghraib, torture was condemned in the Detainee Treatment Act of 2005, but the other practices received the endorsement of Congress and often the acquiescence of the Supreme Court. Now they have been endorsed by the new president, a lawyer who professes to be dedicated to the Constitution and the highest ideals of the nation. As a result, many of the transgressions of the Bush era, rather than being denounced as unworthy of our Constitution and easily brushed aside, have been institutionalized. They have become the official policies of our government and are routinely defended as constitutional. Not only must we suffer these transgressions today, but they will inevitably determine what is permissible in the future. They have shaped our understanding of what is acceptable and may serve as precedents for a less reluctant president. Continued in this way, many of the unconstitutional policies first initiated by President Bush in his war on terror have taken on a life of their own, and over the past decade have become durable features of our legal order. As such, they betray the proudest ideals of the nation, undermine one of the pillars of our self-understanding, and deny us, all of us, including President Bush, President Obama, the right to speak of the example of America as we once did, as a beacon for all the world. Thank you.